Hi, I'm Romero, and today I will be talking about due diligence, private placement memorandum, and term sheets, and what they are and what they do. Due diligence. When deciding to invest in a business opportunity, due diligence is used as an investigation tool to further evaluate the prospective venture. It is a general duty to exercise care when doing transactions. Due diligence takes into account all aspects of the target company, including looking into the past, present, and future possibilities of the business. In other words, using common sense when doing business can make for a successful opportunity. Putting money towards an investment could cause a number of professionals to want to conduct due diligence. Oftentimes, this will include investors, investment bankers, attorneys, accountants, loan officers, and other participants involved in a transaction that would call for an independent due diligence. Contributors take part in due diligence for many reasons, mainly to avoid a bad business transaction. Investors want validation the company is where it appears to be. Confirmation is needed that the transaction is in compliance with the investment criteria. To acquire information beneficial for negotiating price assets, defining representation, and useful information for validating assets. Another main reason could be to identify any problems that could be potential deal killer. The types of business is conducted to improve the odds of a transaction, although there is no guarantees one could be successful. Not conducting due diligence could also cause legal problems. Participants in a business transaction can find themselves being sued by clients, investors, customers, or third parties, claiming that a failure to conduct proper due diligence by overlooking defects or false assessments. Having due diligence consultant does not ensure that you would not be sued. It would, however, provide a strong legal defense to a third-party claim. Due diligence also reduces legal issues by alerting a purchaser to potential liabilities that can be mitigated before a closing transaction. A private placement memorandum is a prospectus for shares in a private company, similar to those received by an investor in a mutual fund, stock, or other publicly traded security. A PPM entails the terms of the investment, requirements of the investor, and disclosure and disclaimers related to the business and equity. It is an offering of equity or debt that meets legal exemptions, which does not have to go through the paperwork and expense of registering with the SEC. A private placement memorandum is essential for companies pursuing capital. It is among the top documents needed for an entrepreneur alongside the business plan. A document is necessary for raising capital in the business. If well written, it can benefit both the investor and the writer of the PPM. There are numerous laws that permit the type of private placement, the most common found under Regulation D in the Securities Act of 1933. Under Regulation D, there are separate exemptions for companies who raise under capital $1 million, under $5 million, and unlimited amounts, each with barely different restrictions. Rule 134 is a type of private placement sold only to qualified institutional buyers. Regulation S allows for foreign investors to attain private offerings. A term sheet is a document that states key terms of a proposed investment that is prepared by venture capitalists. A term sheet can reduce the valuation to the entrepreneur because of all the protected causes protecting the venture capitalist that term sheet contains. This is the reason why both parties should have an experienced attorney look over the term sheet. A term sheet is basically a conditional offer. Before the deal is complete, the venture capitalist will examine key contracts such as employee agreements, option plan, registration rights, and so on. Key terms in the term sheet are preferred stock, liquidation preferences, dividends, reverse vesting, and drag-along rights. Venture capitalists want preferred stock because once a company is up and running, they want liquidation preferences and voting rights that provide them with protection and control. There is no way of getting rid of preferred stock, but there should be negotiations about how much preferred stock each person gets. Liquidation preferences are who gets liquidation in the case of an acquisition, bankruptcy, or sale of a company's assets. Venture capitalists want money first. Negotiations should be made about liquidation preferences, or limits should be put on how much liquidation the venture capitalist is able to receive. Dividends are the annual return on preferred stock an owner receives. Entrepreneurs should negotiate for lower amounts in regards to venture capitalists. You should negotiate for non-cumulative dividends because cumulative dividends mean dividends that are not paid will be added up. Reverse vesting is basically saving common stock shares and then earning them over time. Venture capitalists want founders to stay around, so reverse vesting should be negotiated by both parties. Drag-along rights mean that only a minority of shareholders must agree on a sale or liquidation of a company. Founders usually get nothing in this case. Venture capitalists argue that founders should get nothing because the company didn't live up to its expectations, and this is hard to argue or negotiate away. So, time and resources shouldn't be spent on negotiating against drag-along rights. Thank you.